First of all, very warm welcome. My name is Jesper Christensen. I am a partner in the employment and immigration team at BDB Pitmans. And I'm delighted to introduce my colleague, Tim Hayes, who is a legal director, also practicing employment, but with a particular focus on immigration. And we're here this morning really to consider and talk about the employment of EU nationals in the UK, particularly you will be delighted to hear in light of Brexit. So there will be a bit of mentioning of the B word during this morning's talk, but it may make some relief from talking about COVID-19 and so on. So I hope that's all right. Now, the way it will run is I will, first of all, just give a fairly brief introduction to the topic and a few thoughts on how we got here and what the position is right now. But I will leave Tim to do most of the talking really about what is likely to happen in the future. And when we talk about the future, it's really from 1st of January 2021. So we would like for you to have the opportunity to do to give us questions and to have a Q&A session. So please do use your Q&A button as we go through Tim's presentation. Type in, if you have comments that you think we would like to discuss at the end, or if you have specific questions on what Tim is saying, we will get through to the end of Tim's presentation, and I will then try to pick out questions that may have been raised, and we can discuss it, as best we can. And I know it's not the sort of usual interactive forum, but it would be good to hear from you as well. So please do use that button. Can I ask you not to use the chat button unless you have technical issues, because I'll be looking at the Q&A comments specifically. But if you have difficulties logging in or hearing us or anything like that, put it into chat, and our assistant who's helping us this morning will have a look at that and see what, if anything, she can do to assist you. So with that in mind, I think it's time to get on. And as I said, we're here this morning really to talk about immigration, but particularly and specifically about the employment, in the context of employment, and specifically about the employment of EU nationals in the UK at the end of this year. Clearly, as a reminder, the whole system is about to change due to the fact that the United Kingdom has left the EU. We are currently in the transition period. As you know, the government has made it pretty clear that there will be no extension to that transition period. So the United Kingdom will be coming out of the EU completely, with or without a deal, at the end of this year. And as we have all seen from the media lately, the negotiations of a deal with the EU is potentially still on the cards, but are clearly not going well. And we are really coming into sort of the last chance saloon, which has caused and is causing difficulty for people to prepare and to know exactly what is likely to happen at the end of the year. So if you have a business that is relying on the employment of EU nationals in particular, or if you are considering, the continuation or employing EU nationals in the new year, we are trying now to sort of give you an overview of the kinds of things you will be needing to consider really at this point in time. There has been a number of seminars on this topic, and I think we are a little bit further forward this morning, although we may not yet have complete and absolute clarity. What is clear is that the government has now put into law, it's sitting in the House of Lords, but it will become law, effectively a repeal of Section 7 of the Immigration Act 1998. Now, that section is the right on which currently all EU nationals are relying in terms of having the right to enter, to live in the United Kingdom, to work here, and all the rest of it. And that gives the employer the opportunity simply to obtain the passport of an EU. When I say EU, I mean also EEA nationals, so Switzerland, Iceland, and Liechtenstein, and so on. But it gives employers the opportunity simply to ask to see a valid passport, and that is evidence of the right to work. And the EU national doesn't really have to do anything else. They obviously have to register for national insurance and so on, but essentially the right is there. So that has been fairly straightforward up until now in terms of hiring, recruiting EU citizens. You essentially ask them for the same thing as you would ask any employee, including UK citizens, which is simply of proving that right to work. But Section 7 repeals that. So at the end of the year, rights are being removed. That is the rights of EU nationals. It stops the free movement of labour, and that's clearly the intention. And the government is wanting to put a different system in place. And it's that different system and the changes that Tim will talk about very shortly. At this point in time, of course, there are a number of existing EU nationals who have lived and worked in the UK and who are already here. And as I'm sure you have heard, the government has launched an EU settlement scheme. And under the scheme, any existing person who lives and works in the United Kingdom and their family, if they're EU nationals or other nationals, should register under the EU settlement scheme. And that is open and will remain open for anyone who is here by the end of the transition period, so by the end of this year. It's something you may want to consider in terms of your own workforce, whether you need to provide assistance, awareness, and so on, because you will obviously want to retain those employees. And what the settlement scheme does, and it will be open for people to apply until next June, so it will remain open even if people haven't applied by the end of the year, but provided they're already living here and are eligible, it will remain open and they can apply, and that will preserve essentially their rights as they are now, i.e. the right to continue to live and work in the UK, to access certain benefits and so on and so forth. And that's all been agreed in a very long and tortuously negotiated schedule in the Withdrawal Act. So those rights should be safeguarded, but they are requiring people to apply. I think at the moment something like 3.4 million EU nationals have applied under that scheme. And if you know of anyone who hasn't done so yet, you will obviously want to encourage them and potentially give them support with that application. That might be letters of evidence of employment and so on, which I know a number of people are asking for. But yeah, and also then that route for some, if they want to, can lead to the opportunity to apply to naturalize and obtain British citizenship. And if that's something people are considering doing, then obviously it's a matter that Tim can help with. But what about the future? This is really, we're really at a point now where rights have been taken away. On the face of it, the question is then, what will the opportunity be for EU nationals if they want to come and live and work in Britain? What will they be? What rules will they be under from the 1st of January? And this is really what I'll hand over now and ask Tim to talk to you about in some detail. We do know something about it now. As I said at the start, the negotiations are still ongoing. So what Tim is going to tell you is obviously what we think will happen, or what is likely to happen, unless there is some major breakthrough in the negotiations that were to tweak the rights of e-nationals to give them better rights than what Tim will tell you about now. As I said, if you have questions, comments on Tim's talk, then please put them in the Q&A and I'll have a look as we go through, and we will have a catch-up Q&A session at the very end. So over to you, Tim. Thank you.
No difficult ones though, please.
No difficult ones.
So it looks like, Jesper, Brexit isn't done, and we don't have an oven-ready deal. It's quite interesting, isn't it, that we're doing this presentation during a week when the negotiations seem to be descending into, well, chaos really, and so much acrimony. And I guess it kind of underlines the importance of taking the changes that are going to happen next year quite seriously. So what I'm going to talk about firstly are the changes that are coming in next year. Second, what you need to do when you're applying for a license, the process that you go through. And third, what you need to do in order to maintain the license once you've got it. That very, very important raft of considerations that come once the license is in place. So I hope there's something for everyone, those of you who are sponsors and those of you who are looking at the process of potentially obtaining one. So going back to put this into some kind of historical context, the government set out last year in its election manifesto. If you can all remember the 2019 election, and it said that once free movement ended, it would deliver what it's described as a new points-based system to attract what it referred to as the brightest and best talent from around the world. And what it did was then to commission advice from the Migration Advisory Committee, which is the committee that advises government on immigration policy. It asked for advice on what a new Australian-style points-based system could look like, as well as the salary thresholds that applicants under the points-based system have to earn in order to be eligible to be sponsored onto a job. And the committee then came back with its report on both those issues in January, and then the government published its policy statement in February, setting out further information on the new system for European nationals wanting to come to the UK from January onwards. And since then, we've had some further details in July, but nothing new really. So what we've got is a broad kind of outline. We haven't had too much detail. We've had an indication of what the government's thinking, but no new guidance. And as many of you will be aware who have dealt with the points-based system, what we have at the moment is some very complex rules, some really complex guidance that underpins the points-based system. We don't really have much of that. What we presume is that it's going to be a tinkering with the existing system, a kind of rebrand, really, but that the changes are not going to be wholly substantive. I guess we're not really talking about a new immigration system. We're talking about a tinkering of the existing one. So let's go through the main changes. I think if we go on to those changes that are listed on the screen. So we have first of all, if I can take the salary levels. I mentioned that the minimum salary threshold would drop. So at the moment, if you want to sponsor someone from overseas, from outside the European Union, they would have to be earning a minimum salary, unless certain exemptions apply, of £30,000. And that is relatively high for particularly employers who are not based in the sort of southeast where salaries are higher. And that's going to reduce. So you would be looking at having to pay a new migrant from outside of the UK around £25,000. That drops for PhD roles, so roles which are at a PhD level, or roles that are on the shortage occupation list released by the Home Office and updated periodically. So that lower salary is going to be £20,480. So that's a much better, well, I guess it opens up the potential range of jobs which can be sponsored. Another change which will help the range of jobs to be widened is the lowering of the skill level. At the moment, if you want to sponsor someone, not only have you got to guarantee that you're going to pay them at that right salary threshold level, you've also got to guarantee that it's at a certain level, and it's degree level at the moment. So the job that you sponsor someone into has to be a degree level post. It doesn't necessarily matter what personal history the individual's had, as long as the job is at degree level. So that's going to drop, and it's going to go down to A level, what they refer to as RQF level 3. Currently we're at RQF level 6, which is degree level. It's going to drop to A level. So those two changes are essentially really to compensate for the lack of potential EU workforce. I don't know if any of you remember when the points-based system was originally introduced back in 2008, there was a tier 3, which was supposed to be for low-skilled workers. And that was never introduced because it was felt that at the time and ever since that labour from the European Union could compensate, and there wouldn't be any reason to bring in that low-skilled work category. And I guess with the lowering of the salary threshold and the lowering of the skill level, that will go some way to compensate for the absence of new workers from the European Union. What we don't have, though, is a low-skilled worker category. So we have A-level jobs. Anything below that is not going to be eligible for sponsorship. I think there is a seasonal agricultural workers programme, but there is nothing else at the moment, and the government doesn't seem to be willing to entertain proposals to introduce a low-skilled worker category. A few other changes. I don't know if any of you are familiar with the cap on restricted certificates of sponsorship. When you're a sponsor and you want to sponsor someone from overseas, you issue them what's called a restricted certificate of sponsorship. Historically, there has been a limit every year of 20,700 of those restricted certificates of sponsorship. So I guess it's a way for the government to say, well, you know, we're limiting migration, and we will only accept a certain number of migrants into employed roles in the UK. In reality, the cap has never really been hit. I think there was one period a couple of years ago where doctors and nurses were included in the cap, and that led to quite an acute shortage of restricted certificates of sponsorship. And doctors and nurses were then taken out so that there wasn't such a pressure on the numbers. And ever since then, the cap has never really been reached. So it's been a cap in name only and not in practice. So that's the indication, is that will be done away with. Something else that will be welcome news for applicants and employers as well are the switching rules, which it looks like are going to be relaxed. I think it's quite a frustrating facet of immigration law that you can only apply for certain types of visa within the UK if you have a certain type of visa. So I'll give you an example. If you are here as a tier 5 youth mobility worker, so you come from, for example, Australia or New Zealand, and you have this visa where you can come here for 2 years, you can work for any employer, but there's a limit, and after 2 years you've got to go back to your country of origin and apply for another visa from there. And it's been quite frustrating where you have an employer that wants to continue to employ the individual and they simply can't apply from within the UK. And during the coronavirus pandemic, we've had a concession in place where the government has basically said, well, you know, we're going to relax these rules. You can apply for a switch within the UK. And I think it's worked really well. I can never really understand why you couldn't you couldn't switch from a wider range of visa categories than you otherwise should be able to. And if you think about it, it's quite environmentally damaging as well. People travelling back, you know, possibly to the other side of the world simply to make an application, which would take 2 or 3 weeks, and then they'd come back. And of course, you have the employment complications inherent in that as well. Do you maintain employment? Do you cut continuous employment? You know, lots of people can't do their job from a distance. So, you know, I think that's a really positive development. The resident labour market test also looks like it's going to disappear. Again, music to our ears, and it should be music to the ears of employers up and down the country. The resident labour market test, for those who aren't familiar with it, is when you have to advertise. There's certain exemptions from it if you're paying someone a very high salary, for example, or you're offering a job to someone who's switching from a tier 4 visa. You don't have to do it, but in most other circumstances, you have to advertise a vacancy to the resident labour force before you give a certificate of sponsorship to an individual to apply for a visa to do the job. And it's always been a bit of a fiction, really. 9 times out of 10, employers know exactly who they want to employ. Take the example of the tier 5 visa holder. Might have been working that position for 2 years. The employer knows and likes the individual and wants to give the substantive role to them. But they have to go through this process and advertise for 28 days in certain media. And, you know, you have situations where you have 500 applicants, let's say, and lo and behold, the only person, and that's the test, the only person who is suitably qualified and experienced to do the role is the one who's been working in your organisation. Now, obviously, you have to go through an objective recruitment procedure in order to comply with the resident labour market test, and that can be a difficult thing to navigate through. And I think the Home Office really knows, as well as everyone else does, that it's really a fiction, and it is not a practical thing to go through. And with the disappearance of free movement, that's one obstacle which is just an anachronism, I think, in the new system. So it looks like that is going. Another thing that's going is the cooling off period. I don't know if any of you are familiar. So if you have a tier 2 visa and you leave the UK, you finish that visa, you finish the job. If you want to reapply to come back to the UK under tier 2, you have to cool off. You have to wait 12 months in order to then reapply. Again, bizarre, I think. I mean, it's just not practical. And I've never really understood the benefit of it, really, apart from just simply deterring migration. So that's going. Well, the government guidance is only, it refers to it being removed in relation to the intra-company transfer route. It doesn't say anything about the tier 2 general, or what's called rebranded the skilled worker route. So I really hope that it disappears for all routes, but we'll have to keep an eye on that. So that's the points-based changes. I should also, I guess, refer to the new student sort of post-study work, what's called a graduate visa option, which, those individuals who are here on an undergraduate or master's degree can apply for a 2-year graduate visa. If you're a PhD student, you can apply for a 3-year post-study visa. They won't need to be sponsored, so they can work for anyone, and they can then switch into points-based system, work routes on expiry or before that, if they want to. So, broadly, obviously, there's the problem of free movement, but I think these are positive changes to the immigration rules, which arguably should have come around perhaps a little earlier, and not as a result of Brexit. But anyway, so one thing which I think is mentioned on the last point of the slide is the cost of it. I think that's something that is probably the biggest thing that we've all got to get used to, both as employers and knowing what it's going to cost if it is indeed the case, and it looks to be the way, that Europeans are going to be brought within this points-based system. Just looking at what the cost of coming to the UK for work will be, if you think that for let's take a 3-year visa, and you think that the cost of application is going to be, well, it's about £600 to £700, let's say, for a 3-year visa. That's per family member. So you're looking at about almost £3,000 for a family of 4, for example, if the individual wants to bring their family members. You've also got the cost of add-on services, so you can pay for priority processing of your application, or a company sofa when you go to the biometric appointment. Lots of things which bump up the cost then of the visa. So that's the visa application fee. You've also got to think about the immigration health surcharge. Now that's currently some £400 per year of leave. That's going to go up next month to £624 per year of leave per person. So there's going to be a slightly reduced rate for children, 470. But that's still a lot of money. And when you think that at the beginning of last year, the immigration health surcharge was £200 per year of leave, and look at in just the space of a year and a half, 2 years, what it's increased to. I mean, that's a big cost. You look at that family of four again. That is, and I've done the sums. It's about £3,700 for the adults in that scenario of 3 years. £2,820 for the children. So you're looking at about £6,500, and you add that to the cost of the visa, and you're approaching about £10,000 for a 3-year visa. And of course, then the visa has to be extended after 3 years, and then there's a settlement application, presumably or possibly at the end of the 5-year period. So it's an expensive business. And actually, the Migration Advisory Committee, when it came back in its report a couple of years ago on the Tier 2 system, said, well, making the system more expensive is one of the best incentives for UK employers to take on UK workers, because at the end of the day, it's going to be too expensive to take on labour from outside the UK. And looking at those numbers, you can quite easily see how that's the case. Of course, there was a bit of uproar in the summer when it emerged that health workers, doctors and nurses, were also having to pay the immigration health surcharge. So that's been, as widely publicised in the summer, that's been amended so that there's concession for that type of worker. But it's still a very expensive business, and especially when you think that obviously healthcare is being paid for via taxation anyway. So if we move on to the next, we'll come to the charges for sponsors in a moment, but if we just move on to the next slide. So let's look at the process of applying for a license. I guess this is obviously going to be more relevant to those of you who haven't got a license, but reviewing the process that you went through for existing sponsors, I think is also going to be useful, because these are questions which you'll have to have in your minds as you go through a potential compliance visit as well. So I hope it's relevant to all of you. So you might think that given all the fees and the administrative burden, you might think, well, why bother getting a license? And the obvious answer is that if EU workers are key to your business, and I'm not just talking about existing EU workers, obviously there is going to be a requirement going forward for you to have renew that workforce and offer jobs to European workers who are not currently resident here. You are going to need a license. That's going to be crucial to your business. Now, the Home Office historically has wanted to kind of trim the number of sponsors on its list. I think there are about 31,500 sponsors on the register of Tier 2 sponsors, and that's publicly available document. You can have a look through all the list of sponsors in the UK. And we used to advise against applying for a license on a speculative basis, because typically the Home Office would only grant them out of need. You'd have to identify why exactly you wanted one and justify it. I guess that is less stringent now, and I think you could make a speculative application for a sponsor license on the basis that Brexit's happening and you may need to employ workers on the other side of the 31st of December this year. So, it's not as if now you're going to have to point to, well, we've got a vacancy, we can't fill it. You can make a general speculative application. And in fact, the government is actively encouraging companies to apply anyway. And what you do is fill out an online application. You have to put key bits of data in, such as your head count, what branches you have, what sector you operate in. You've got to nominate key personnel, and that would include an authorising officer who's there in kind of a presidential capacity, who sort of oversees the sponsor license and has to sign things off and that kind of thing, and a level 1 user who does all the sort of administrative stuff that comes along with sponsorship, so issuing certificates of sponsorship, updating details and that kind of thing. And once you've completed that online application, you sign a declaration and you submit it, and the paperwork has to be sent to the Home Office within 5 days of that submission. Now, typically, you've had to send it by post. They would only have accepted paper documents, but now, because of the way things have changed during lockdown, what you have to do is submit those documents by email, which I think is a far easier process. And we're not going to go to it yet, but on the next slide, there is an image of Appendix A, and Appendix A is the crucial document which lists all of the types of documents that you can send to the Home Office in order to prove that your business exists. It's things like financial accounts, premises lease that's been signed by both parties, PAYE letters from HMRC, that kind of thing. But as is always the case with documents issued by the guidance issued by the Home Office, you have to be extremely careful that you are complying to the letter with the description of the documents, because if they're rejected, then that may mean that your application fails. They may come back and request clarification or a further document, but they may not do. So my tip is to get it absolutely nailed on at the first attempt, and to make sure that you're complying with what the guidance says you should submit in the format that is described in that document. Processing times, I think they vary hugely, and I think it's become even more difficult to say with any certainty what the processing time is because of lockdown. Historically, they could vary anywhere between a couple of days to weeks. And my sense is that the speed of approval of the application will really depend on what kind of sector you operate in and what kind of profile your company has. So, for example, if you operate a restaurant in the hospitality industry, that's likely to come in for more scrutiny, because the Home Office will look at it with more circumspection than they might otherwise do with a firm of architects or lawyers. So it just really depends on what they make of your company profile. It will also depend on whether they want to make a compliance visit, so a pre-license compliance visit, which is very much like any other compliance visit for those of you who already have licenses. And this is why I say this part is also relevant, because you may be visited as part of that process, and what will happen is that a compliance visitor, normally announced, they will normally give you some lead-in time in order to prepare things. We'll come in and sit down with you, and we'll go through your application, the supporting documents. We'll ask you lots and lots of questions about your organisation, about who you employ, the position that you want to sponsor people in for, if that's the case. And it's normally quite an uncomfortable experience, and it normally takes a good few hours for the compliance visitor to go through all of the information which they say they have to. Yeah, I mean, I've been present at a good few compliance visits now, and typically they've gone very well. I think I remember being at one where the compliance visitor was very impressed that the client had premises, because he'd been to one visit the week before and the premises didn't exist. So having premises that exist is a good move. But yes, generally you just have to prepare very, very well for those compliance visits. In terms of the cost, So we are looking at an application fee, which hasn't changed for years now, of £1,476 for medium and large sponsors, and £536 for small sponsors and charities. Added to that, once you have the license, you have a £199 assignment fee to assign a certificate to someone who you want to sponsor. And you also need to think about the immigration skills charge, which is £1,000 per year of leave, apart from in certain circumstances, which I won't go into now. So potentially for someone for that 3-year visa, you could have an additional cost of £3,000 in order to meet that immigration skills charge. So if we go on to the next slide, keeping the license. Yes, so sponsors often fall into the trap of going through this process, which can be, long and involved, and then sitting back, taking a deep breath and a holiday and forgetting about it. And I can't stress enough that that is definitely not the end of the process. And there are a number of compliance and reporting duties which you as the sponsor have to keep on top of, and that is immensely important. And so, I mean, as a starting point, so on the left-hand side, the image on that slide is Appendix A. So those are the documents that you have to supply as part of that application. On the right-hand side is the Tier 2 sponsor guidance. It is a long read, I appreciate, and it's not the most of enthralling novels, but it's something which you have to keep very much in mind. And it contains some pretty boring bits, but it can contain some really, really important reporting duty bits and sections which you really need to be aware of. And if I can just take a few of the sort of common pitfalls. So firstly, if you change your name, even if the company entity is not changing at Companies House, if you change your name, that has to be reported to the Home Office. If you change your location, or you want to add another location that a sponsored worker is going to work at, you need to notify the Home Office, and the Home Office has to confirm that that's okay before you're entitled to basically station someone there. So when you make your initial application, the Home Office doesn't keep a record, or you can't see on your Home Office portal which premises have been added. So it's often a bit difficult to work out whether, if you're a large company, all of your premises are included within that license. But what I would recommend is that you keep a record, both when you apply for a license, if you have more than one premises that you operate from, and as you go through, so that you know exactly what's been reported to the Home Office. It's very easy, I guess, to go through a move, a premises, and for the Home Office not to know. And I guess in the worst case scenario, it might make an unannounced compliance visit to your old premises and realise that there was no one there. Maybe that's what happened in the compliance visit, where the compliance visitor said, well, at least you've got premises. So something to keep in mind. Corporate structure as well is another tricky area. So for example, if your controlling shareholding is sold, so a controlling interest in your company, the sponsor license entity, is sold, or there's a demerger or a merger, you need to report that to the Home Office within 20 working days. And it's probable that you will need to apply for a new license. But you've at least got to report it to the Home Office, and then they will inevitably confirm, if you take the view that you didn't have to apply for a license, whether you do or not. But it's, again, so often missed by sponsors, particularly when you're looking at perhaps just a corporate restructure, and nothing's really changed other than perhaps the holding vehicle has changed or whatever. And sometimes immigration is sort of driven down to the bottom of the list of considerations in a corporate restructure, but it should be definitely high up on your list of priorities. So that's at company level. Now, just in terms of reporting on individual migrant workers, you'll need to be aware that certain things need to be reported within 10 days. So, you know, your employee not turning up, for example, you know, it sounds pretty extreme, but, you know, one of the questions which a compliance visitor will have is, how do you monitor people turning up? You know, you might think it's unlikely, but you will need to have an answer for it. You'll need to have a system in place for monitoring whether employees do turn up or not. Also, if you stop sponsoring them, that's not the end of the story. You need to advise the Home Office through the Home Office portal, the sponsor management system, that you've stopped sponsoring them. Big changes in their role, that also is something that needs to be reported. And also a trap which sponsors sometimes fall into is to give sponsored migrants another job, which is not actually within the job code. The Home Office has, as I'm sure lots of you are aware of, different categories, standard occupational classification codes. So every job basically that's eligible for sponsorship, and those that are not, is categorized by the Home Office. And if you give, or if the sponsored migrant moves into a different job, then that's potentially something that they would need to make a change of employment, another visa application in order to do that job. It might not be the case, but you need to consider whether the changes in their role are so significant as to take them outside of the job code which they were sponsored to do. And changes to key personnel as well. If your authorising officer changes, it might be that the authorising officer and the organisation itself has forgotten about the sponsor licence, or doesn't sponsor workers anymore, or is between sponsoring workers, and frankly they've forgotten about it. You'll need to inform the Home Office when level 1 users and authorising officers change. Obviously, what I would recommend is that you don't think about these points for the first time when you're sat opposite a compliance officer. So, you know, maybe having a kind of a yearly catch-up or 6 monthly catch-up at the very least, where you kind of reacquaint yourselves with the workings of sponsorship and whether the guidance has been updated and whether those updates might have an impact. So guidance is often updated where the Home Office is concerned, and it's a good thing to just keep on top of it. So if you go on to the next slide, this is the usual, if you don't comply with this, this is what will happen. And yeah, these are particularly unfortunate outcomes. If you are found to not be complying with the requirements of the sponsor license, then, you know, if you're not reporting things, then I guess the Home Office could take action. You know, normally, particularly recently, it tends to adopt a more pragmatic approach, but you can't guarantee that that's going to be the case, and particularly not with perhaps more severe transgressions of the sponsor license regime. So it could suspend a license. It could downgrade it to a type B license, where you have to go through a kind of rehabilitation program and prove that you're a responsible sponsor and pay for the privilege of going through it. And then after a few months, once you've been inspected again, you'll get back up to a grade A license. You know, obviously that has a lot of impact on your on the individuals which you're sponsoring. And obviously, if it's revoked, that's possibly the worst case scenario. Then that would have you know, really quite a severe impact on both the individuals who you're sponsoring currently, and of course your ability to function as a business, depending on how key European workers are to what you do. And of course, I'm sure you've all heard about the civil penalties of £20,000 per illegal worker. This is really in relation more to right to work checks. So, you know, if you get a right to work check wrong, the chances are that you could be in line for a fine unless you have a statutory excuse. And there are criminal offences in terms of employing people illegally, and of course the reputational commercial damage that flow from you know, adverse publicity flowing from issues with sponsor licenses and immigration. So I think those are and given the time, I'll probably stop there. And I don't know if there are any questions which anyone has. Yes, but I don't know if...
Well, thank you, Tim. Thank you for that. And there's quite a lot to take in there. We have had quite a number of questions come through, about 8 or 10. So maybe what I should do, Tim, is do a sort of a quick fire round of Q&As. So I'll ask you the questions, and you can give us a hopefully straightforward answers to some or all of these. But if you have any more questions for Tim on these topics, then please do keep adding them to the Q&A box. Now we'll keep going until 10 o'clock and see how far we get. But the first one is from Alan. And Tim, what's the position for a married couple already living and working in the UK, where one partner may be from the UK and the other from an EEA country?
So I guess in that circumstance, well, the individual from the EEA country would need to be applying under the settlement scheme for pre-settled status or settled status. I guess the advantage to being married to a UK national, there are many, is that in order to get citizenship, normally you would have to wait a year after settlement in order to apply. But if you're married to a UK national, that doesn't apply. You can get settled status and apply immediately for a passport. So that should be the route here, I think, is to apply under the settlement scheme if they haven't already. And then if they get settled status and they want to opt for citizenship, that's something that they can think about.
They can then go through the process of naturalization more quickly. Yeah. Okay. Question from someone is, can an employer ask to see documentation that an employee has registered under the EU settlement scheme? And I know, Tim, this is something we discussed yesterday in terms of how do employers now distinguish between hiring an EU citizen who has been living here for a while and has the settled status, as opposed to a new one?
Because those right to work checks, essentially you can accept an EU national's passport or ID document until the end of June next year, and that would give you your statutory excuse. So if it was found that they were working legally, you wouldn't be guilty. You wouldn't have a civil penalty imposed because you accepted a document that was correct to have accepted.
Is that because the opportunity to apply for settlement still it doesn't expire until next June, so people could have been living here but just not got around to it yet?
So I guess the problem is that there's obviously that 6-month grace period or gap when just thinking about the alternative, you could have someone who arrives on the 2nd of January who is not eligible to apply under the settlement scheme. And how would an employer distinguish between them and someone who has the right to apply under the settlement scheme?
So there's going to be a hiatus here, because when you register under the settlement scheme, you don't get any kind of card or anything like that from the government. You simply get put into a computer system, which employers will then be able to access to double check that this person has registered, but in the next 6 months or the first 6 months of the new year, this is going to be a bit random because, as you say, people may or may not have registered.
Legally, an EU national could provide evidence, could provide their passport, and that would be all that they needed to do. So, you could ask everyone for proof of.
But down the line, say next, once the first year has passed, essentially, the employer will need to check the government database.
That's right. So
to make the distinction, yeah.
People might be familiar with the employer checking service. So there is a way, and there will be a way, and you can now, in fact, if you go through the settlement scheme, you can provide evidence that you've gone through it, and you get a printout basically.
Yeah. So the answer is employer can see it, and indeed should see it, should ask to see it, and that will become more common in terms of the process. Right. The immigration health surcharge, does that have to be paid during the visa application process,
The
or
health
does that?
surcharge does, yes. So you can't submit an application for a visa if you haven't paid the immigration health surcharge. So that's paid as part and parcel when you come to pay for the application itself.
So for your family of three, if you're applying for a 3-year visa for you and your family, at the point of application, and you have your job and so on, or offer at least, you essentially have to cough up 3 years worth of visa fees plus health surcharge fees at that point.
There's a good question there about who pays for the visa application costs in immigration. I mean, that's often a question that comes up because there is no legal obligation for the employer to pay. It could be something that you agree with the individual.
But there's a lot of money up front, isn't it, before you even know if you're going to obtain the visa? What happens if the application fails? Do you get your money back?
So if it's been decided upon the visa application fee isn't refunded, the IHS, the immigration health surcharge, is refunded. Of course, you're not from it. So, but it might take a bit of time to come through.
Yeah. Okay. A couple of questions about the sponsor license. Here's one from Eve. They have a sponsor license that expires in March next year. Should they be applying? Should they apply for a license under the new rules, or what will the existing license cover until it expires?
Existing license will cover it. So there is no transition to a new sponsor license for those who are already sponsors. So yeah, there is.
So you can continue to use your sponsor license,
yeah,
which you have already.
Absolutely.
Okay, then Catherine says that they have, or they've read that a number of applications for settled status have been rejected, and that number has increased dramatically recently. Is that correct? And what can people do to try to prevent, their workforce applications being rejected?
The problem sometimes arises if an individual applies for settled status or pre-settled status, and there is no record of them having worked in the UK. For example, if you've worked in the UK, it's very easy for HMRC for a long period. It's very easy for HMRC or for the system to identify that you've been working, and inevitably it gets approved fairly quickly. The problems come where you're not able to show that you've been working, or they haven't got the figures in the system, and they ask you for more information. And if that's the case, I think most of the rejections have been on the basis that the applicants themselves haven't been providing information that cover the 5 continuous years if they're applying for settled status, or other more limited information if they're just applying, of their residence if they're just applying for pre-settled status. So it's not such a problem for employees. I think most of the problems are with those who are self-employed, those who are students, and who can't show that they've been resident here.
Yeah, I do know of another issue here which has arisen particularly in higher education and also in jobs where people have to travel a lot, because there are residency requirements, and you have to basically list each and every occasion you've been in and out of the country for the past 5 years. And if you've been out too much, that can also cause a rejection. So you have people who've gone abroad to do, as part of their jobs, as part of their research, and so on. And I know of a number of senior lecturers who found it difficult. At the moment, there's still an opportunity at least to get pre-settled status and then, wait again. But because of this residency test and the number of days you must be in the UK to be eligible, this has also caused problems. I think, Catherine, the answer is if you fail the first time, you should encourage them to try and apply again and see if they can get the paperwork in order and at least get pre-settled status, which is something that it's the same rights, but then if you remain for 5 years, you then obtain full settled status.
There's a question from Emma, which I think is quite a good one, actually, if I can just refer to that one. Yes, so can a license be for a holding company and all its subsidiaries? Or should each operating company have a separate license? And that's a question which both are possible. You'll need to ask yourselves I guess the advantage to having one license for everything is that you cover everything within one license, and it's administratively a bit easier. I guess the advantage in having separate licenses is that if anything goes wrong with one of the licenses, then it doesn't affect your whole organization, and you're perhaps a bit more agile that way. I've generally tended to deal with organizations that have one license covering all subsidiaries and locations. But I guess if you have subsidiaries which do markedly different things, it might make sense to actually have, different ones, different licenses. But that's definitely, both routes are viable.
Yeah. Jill's question about the grade A license, but they've only been issued with one unrestricted license, and would European workers have to apply for an unrestricted or restricted sponsor license?
So this is the difference between restricted certificates of sponsorship and unrestricted certificates of sponsorship. And this is quite a tricky thing, and I'm not sure we'll really apply going forward anyway. So, so restricted certificates of sponsorship are those coming from overseas who are subject to the cap that I was talking about earlier on. Unrestricted will show on your allocation of certificates of sponsorship on your sponsor management portal, but those are only for people earning very high salary coming from overseas, or those who are already here anyway. So I think that, well, it's given that the cap's going to disappear anyway, the likelihood is that we'll only have one kind of certificate going forward. So I guess it's not really relevant.
And then finally, we just have a few COVID-19 related questions as well. In relation to COVID-19, the widespread move to working from home, what are the Home Office's expectations about reporting? This is the reporting workers' location of work, and I think the changes, you talked about reportable changes, and then one that is, I suppose, aligned. Is there any likely grace sort of period for applications during the COVID-19 pandemic?
I mean, I would still report it. I can't remember if the Home Office's concession has now ended, where you don't have to report home working arrangements, but I would still report.
So this is currently for non-EU, non-EEA workers, obviously, but anyone else who is currently working on a license.
Yeah. So ordinarily, because you have to tell the Home Office where the person is working, if someone moves to a home working arrangement, you would have to report that through the sponsor management system, but that hasn't been the case during COVID. I'm sorry, but I can't recall whether that's ended or not, but I'll have a look at that and get that out in the Q&A that we're following up with.
Yeah, and I suppose a final question from Liz: if someone has missed the boat and not got themselves registered as as an EU under the settlement scheme, and we're mostly past June 2021, effectively that person has lost their rights, and we would have to start again, I assume, to try and obtain a sponsor license and finally get a license for them.
Yeah.
That is still the government's intention, isn't it? That you effectively you get yourself registered, or at least potentially lose the right. We'll see. We'll see. But I think the settlement scheme has been, as I said before, I think it has been advertised very widely. It has been taken up very widely. If there's something like north of 3 million people are registered under the scheme, that must be a pretty high number of existing EU citizens living and working here.